Hello, dear learners. Myself Pradyumna Sharma, Assistant Professor in the Mewar University, Faculty of Legal Studies. In this Unit 4, we are about to learn the law related to equality and empowerment of women. Under this, there will be two laws which we will be discussing is the Maternity Benefit Act of 1961 and the second, the Equal Remuneration Act 1976. These are the law related to the equality and empowerment of women in the industrial law. First, we are going to learn about the Maternity Benefit Act of the 1961. This act was passed by Government of India in the 1961 to provide maternity benefits and protects the employment of women during the maternity, as India has a 50% population of a woman and it has been left out without the job and without the proper benefits of uh, their employments which the male accrues. So the Maternity Benefit Act 1961 Act ensures that female employees do not face any discrimination to the men or any other person in the workplace due to the pregnancy, because the pregnancy is a natural phenomenon in the woman. The Maternity Benefit Act is applicable to the women in the organizations, in such organizations who has 10 or more than 10 number of employees. The Maternity Benefit Act 1961 has been amended sometimes. The one of the most and the best amendment in the act was passed by the legislature in the year 2017, in which historically it has increased the maternity leave from 12 weeks, that is 3 months, to 26 weeks, that is 6 months. In the year 2017, the maternity benefit leave has been increased from 3 months to 6 months. It is a historical amendment in the act. This act has also introduced the provision for work from home arrangements for women after the post maternity leave. In the year 2017 Amendment Act, it also introduced a provision for crèche facilities in the establishments where there are more than 50 number of employees. The objective of the Maternity Benefit Act is to ensure the constitutional provisions, uh, as it is a provision in the articles 15. There will be equality, opportunity of equality in the jobs, and it also provides a positive discrimination to the women under the fundamental rights in the Constitution of India. So the objective of the act is to validate the constitutional rights provided to the women. The maternity benefits also ensures health and safety of a woman. So by promoting breastfeeding to the child and recovery after the post delivery. The maternity benefits also discriminates workers on the grounds of pregnancy. Some of the key provisions of the Maternity Benefit Act, this since this is a special law related to equality and empowerment of the woman, so one of the key provisions of the act is the 26 weeks of maternity leave for the first two children, and when the woman gives birth or is pregnant for the third child or more than his third child, then also the woman is entitled for the 12 weeks of leave, that is 3 months of leave for 3 or more than 3 children. Woman is empowered for the full wages during the maternity leave. It is envisaged in the Maternity Benefit Act of the 1961. This Maternity Benefit Act also provides a medical bonus, that is one time medical bonus to the woman worker, and access to free medical care. The question arises, who is eligible for the benefit under this Maternity Benefit Act 1961? Only the women are entitled or eligible under this Maternity Benefit Act. In the establishments or company where are more than 10 or 10 employees, then the woman who is working in that establishment is eligible under this Maternity Benefit Act. The woman who has worked for at least 80 days in the last 12 months before the date of expected delivery, then the woman is entitled for the benefits in this 1961 Act. One of the best provisions is that the adoptive and the commissioning mothers are also made eligible under this Maternity Benefits Act. It is not a natural birth process to the child, but adoption, and the commissioning mothers are also a mothers, and they need time and benefit to raise the children and to recover from uh, their motherhood. There are provisions for leave in the Maternity Benefit Act, which has been increased to 26 weeks in the 2017 amendment. There are two types of leave, which is antenatal and the postnatal. Antenatal leave is the leave before the child's birth, and the postnatal leave are the leaves which the woman can entail after the after giving the birth to the child. Antenatal leave can be taken for the medical checkups, and the woman needs rest, and uh, this leave can be utilized after the approval of the employer. The postnatal leave can also be availed at the birth time of the child, and these two leaves constitutes total number of 26 weeks of leave, that is more than 6 months of leave in the Maternity Benefit Act. During the pregnancy, the women are frightened that they may lose their job, they may lose their work, they may lose their employment. So there is a protection of employment under the Maternity Benefit Act. Mothers are the natural guardian of this world. They gives a birth to the child, and this is a natural process, so they need to be protected for the employment, so they can work after giving birth to the child. So this protection has been provided in the Maternity Benefit Act, and it says there is no dismissal during the maternity leave. No employee, no employer can dismiss the employee only because of the reason of her pregnancy. There is a protection to the woman employee to return to the work after the maternity leave. It is a right of a woman employee who is having the benefit under this Maternity Benefit Act has a protection to return to work after the maternity leave. And in the 2017 Amendment Act, it has also instituted a provision uh, such as the work from home provision after the post delivery. The woman may be entitled with the work from home job, so they can have rest after the delivery. So these are the protection in the Maternity Benefit Act of 1961. This is a special legislation. It protects the woman for her motherhood to give birth to the child. It also safeguards a woman to not work in the hazardous conditions. The woman who works in the hazardous conditions, such as the cement industries, chemical industries, mining, they can be at the time of giving birth to the child should be moved to the safer work environments. They should not work during the pregnancy in the hazardous conditions. The maternity benefit to the women employees impacts on employers because the employer has to pay the salary to the woman employee, so has an impact on the employer. So employer must provide a safe and supportive work environment for pregnant employees. It is a duty of the employer. It is also a duty of the employer to ensure that the employees are aware, the women are aware of their rights under the act. It is also a duty of the employer to maintain records of maternity leave and the benefits, who has utilized such benefits. There are challenges and criticism to the maternity benefit. There are compliance issues in the small employers. It is because the small employers has less amount of profit compared to the large companies, so they lack the awareness. They make the employee frightened that they may lose their job, and they do not provide the benefits under this maternity act. They generally don't hire the woman employees only because of the reason she may be pregnant and they will have to pay the woman uh, for that maternity leave. Obviously, when the woman is pregnant, she should be avoided such hectic and hazardous works. So they will have to, employees will have to take long-term leaves, and these leaves is of 26 weeks under the Maternity Benefit Act. So this is some sort of tingling mind to the employers, so they avoid um, the women to hire at such periods, and they frightened them of losing their job. This act has a limited coverage because the self-employed woman cannot get the maternity benefits. Women who work in the informal sector cannot get the benefit of the maternity benefit act. So these are the some challenges, such as the limited coverage only to the formal employees of the formal sector. This is one of the challenge in the uh, maternity benefit act, which is a law related to the equality and empowerment of a woman. The empowerment of a woman benefits to society. It promotes gender equality. Eh, It is also a directive principles to the state policy under the Constitution of India to provide uh, equal remuneration to the employees rather their gender inequalities. Maternity benefits improves child welfare through the promotion of breastfeeding. It encourages employees' loyalty and well-being, fostering a healthier workforce in the industrial sector. So, in the conclusion of the Maternity Benefit Act 1961, which is a law related to equality and empowerment of a woman employee, the Maternity Benefit Act plays a crucial role in the rights of women workers in India. Yet, it is not sufficient. It needs to be, these benefits need to be implemented in a broader and stricter way. The amendments in the 2017 that Government of India made to increase the 12 weeks of maternity leave to 26 weeks is a historical amendment in the maternity benefit acts to the women employees. Maternity Benefits Act 1961 contributes to the well-being of the woman. It contributes to the well-being and health of the children and promotes the sensitive employment policies. So, the Maternity Benefit Act 1961 is a law related to equality and empowerment of a woman. The another act of the Equal Remuneration Act 1976 is also a part of this unit, that is Unit 4 of the Industrial Law. The Equal Remuneration Act 1976 has to be laid down in the parliament because of the reason that the women workers, they were doing the same work for the same amount of time but was paid less compared to the male workers. It may be because of the reason that employer may think the women are weaker in the physical work than the men. So the government has to lay a bill in the parliament which has been passed later in the name of the Equal Remuneration Act 1976. The equal remuneration, that is equal right, that is equal pay for equal work, which is a directive principle uh, to the state policy in the part 4 of the Constitution of India. So in the year 1976, the Equal Remuneration Act has to be passed to prohibit discrimination on the basis of gender in the payment of wages. It aimed at closing the gender wages, protecting the rights of a female worker in the industries. The key objectives of this Equal Remuneration Act to prevent discrimination and to promote gender equality so the country and the industrial sector can grow. This act is applicable to all employees and employees in the establishment or the industrial unit. This act is applicable to both public and private sector. All the workers, whether male or female, working in any nature of work are entitled to benefit under this uh, the Equal Remuneration Act. The definition of the remuneration is in the Equal Remuneration Act. It provides that the remuneration includes wages or salary and any benefits or perks provided by the employer, example allowances, bonuses. So the Equal Remuneration Act of 1976 prohibited uh, direct and indirect discrimination. Direct discrimination such as the payment of unequal wages from the male to female workers for same or similar work. And indirectly, it created a gender biased job classifications or promotions which resulted in unequal wages. Any wage disparity which is uh, based on the work being or the unequal wages is a discriminatory practice defined in the Equal Remuneration Act. It is a responsibility of the employer to compliance with the equal pay. It is a duty of an employer. Employer is legally bound to pay the equal pay to the male or a female doing the same work. It is also a duty of the employer to maintain the record and make awareness and training. Some enforcement authorities under the Equal Remuneration Act are the labor inspectors. They are authorized to inspect to make compliance with the Equal Remuneration Act. Employees who believe they are being paid less than their counterparts can file complaint with the labor commissioners. So there is a process to file complaint to the labor commissioner. There is a redressal mechanism uh, that the employee can go to the industrial tribunals or the labor courts for the enforcement of their right in the Equal Remuneration Act of 1976. There are punishment for not following the provisions of the Equal Remuneration Act 1976, which are uh, the penalties may be in the kind of a fine up to rupees 10,000 or the employer can have uh, punishment of a imprisonment. So the Equal Remuneration Act of 1976 is to ensure the protection of the equal pay for equal work right under the DPSP, as it has been validated by the Supreme Court of India in many cases, that it is a right to get paid equal pay for the equal kind of work. This act has an impact in the society in the form of social justice. It fills the gap between the male and the female. It empowers women workers to get fairly compensated for the same kind of work. It promotes the gender equality. But there are some challenges in its implementation, especially in the rural areas. There is a resistance from employers, and there is a lack of awareness in the workers, especially in the informal sector. In the informal sector, women are especially triggered to the such challenges. There is a discrimination in the work classification in the male and female. So finally, at the conclusion, in the Equal Remuneration Act 1976, this act is made to ensure the essential to reduce the gender-based pay disparities and empower female workers. It is an act to comply to not discriminate on the basis of gender in terms of wages, and this act fulfills the directive principle which has been directed to the state to pay the equal pay for the same amount of work, whether it has been done by the male or a female. So these two acts, the Equal Remuneration Act 1976 and the Maternity Benefit Act of 1961, are the laws related to the equality and empowerment of a woman. When the woman will be empowered, that is the 50% population of the country, then the country will definitely achieve its aims and objective and will become a developed country. And our government are doing the changes to empower the woman, and it is a constitutional right of a woman to be empowered and to get equal protection in the law. Thank you. This was Pradyumna Sharma, Assistant Professor in the Mewad University, Faculty of Legal Studies. Thank you. Have a nice day.